Today we want to talk about something that comes up in pretty much every conversation I have with hiring managers, and it's related to employment law. And most business owners think they've got it covered until something goes sideways. So I thought, let's bring in somebody who actually knows what they're talking about. And my guest today is Jaylene. She's an employment lawyer who spends her day helping businesses navigating the sort of everything that is related to contract, compliance, and workplace obligations, pretty much. I'd say she's the person that companies call when things go wrong, but also when they want to get things right. So we're going to dive into a few topics today. And yeah, thank you so much, Jaylene, for joining me. Pretty keen to unpack a few of these topics because they're causing quite a lot of confusion for employers and candidates right now. So,
Yeah, absolutely. Yeah, thank you for having me. It's a pleasure to be here. I think it's really important to focus on prevention as much as possible because if you're not focusing on prevention, you can very easily find yourself going through litigation. So this is just one of those steps that we're taking to put information out there to the masses in hopes that it helps employers uh, set up all of their practices in the best possible, set up the best possible framework so that they can get things right from the start.
perfect, perfect. So in terms of topics, we've got a couple of topics that we're really keen on covering. The right to disconnect, well, obviously the legislation and all the confusion that comes after that, non-compete clauses, pay secrecy, and the overtime obligations that an employer has towards its employees. So I know that you prepared a couple of slides. So
I
be
have, yes. What I might do is I'll just share screen. Let me know once you can see it. I
perfect.
think it's helpful to have some written words on the page for those that prefer to read alongside listening. As you mentioned, yes, we will be unpacking a few topics today. So we will talk through the right to disconnect, non-compete clauses, pay secrecy, reasonable additional hours, and I'll briefly touch on wage theft. And then I've put questions there because there might be some written questions afterwards that I'm more than happy to respond to in future.
Fantastic. Thanks. Thank
All
you.
right, so should we get started?
Absolutely.
Okay, let's move to the first slide. So, what is the right to disconnect? So, when we talk about the right to disconnect, we're talking about a new legal right in the Fair Work Act that helps set clear boundaries around after hours work contact. So this is no longer a good practice idea, it's now an enforceable workplace right. So the rule applies from 26th of August 2024 for medium to large employers, and then just recently from August 2025 for small businesses.
Mm.
The key idea is fairly simple. Employees don't have to monitor, read, or respond to work messages outside their ordinary hours unless refusing would be unreasonable in the circumstances. So I think a good place to start is where this right comes from and briefly unpack the legal framework. So I'm going to quickly ground this in the law because it's where a lot of the questions, I find a lot of the questions come from this space.
Mm.
So the right was introduced through the Closing Loopholes Act, which amended the Fair Work Act. There's two important pieces to understand. So there are new sections in the Fair Work Act that created the right to disconnect. It says that employees may refuse after hour contact, but that refusal must not be unreasonable. And then it's also protected by the general protections. Now, what that means is because this is now a workplace right, employees are protected if they use it. So it means that they cannot be disciplined, disadvantaged, or treated unfavorably for exercising their right to disconnect. It sits in the same legal framework that protects employees from adverse action for things like making a complaint or raising a workplace issue. So I think it's really important to set the stage from the beginning. So does another question I often receive is, does this override awards, enterprise agreements, and contracts? So in almost all cases, the answer is yes. So this right, it sits within the Fair Work Act, so no award, enterprise agreement, contract, or policy can remove or limit it. If any existing document suggests that employees must always be contactable or available, then the Act takes priority. Awards and enterprise agreements, they can still include genuine on-call arrangements, allowances, or reasonable additional hours provisions, which we're going to come to later in future slides. But even then, this reasonable test, it still applies. So compensation, for example, compensation or seniority influences what's reasonable, but it doesn't erase the right. So what does the law actually provide? There's the core legal position is this. Employees can refuse to monitor, read, or respond to work-related contact outside of their normal hours. But as I mentioned, they must not refuse in a way that is unreasonable. So this distinction is really important. So the law doesn't ban after-hours contact altogether. It simply removes the obligation to respond unless it would be reasonable to do so.
Yeah.
So I also want to unpack what the Fair Work Commission decides is unreasonable. So there are essentially 5 factors that help define what is reasonable. First, the reason for the contact. So if the matter is urgent, if it's safety related, if it involves an emergency, refusing to answer may be unreasonable. So if it's routine or can wait until the morning, well then refusing will usually be reasonable. The second would be how and when the contact is made. So, for example, a late night phone call is very different from a 6 p.m. email that doesn't require the same night response. The third is whether the employee is compensated. So if the employee is paid to be available, so for example, through an on-call allowance, then responding may be expected. If they're not compensated, then refusing may be more reasonable. Fourth is the employee's role and level of responsibility. So senior leaders or people rostered to handle incidents may need to respond outside of hours. For most employees, that expectation, it simply isn't there. And then the fifth is personal circumstances. And this is the one that I find I'm often discussing. So things like caring responsibilities, health, fatigue, all of these make refusal more reasonable. So taken together, these factors give the law flexibility. It's not a blanket, never contact me, or its contact should be reasonable and responding should only be expected when it genuinely can't wait approach. There are a few factors here that we really need to unpack and think about. So then I want to speak about what the right is and what it's not. So what it is a legal right to decline after work hours contact unless responding would be objectively reasonable. What it's not is a blanket ban on employees contacting staff. It doesn't prevent people from responding if they want to. And it doesn't stop employers from sending information after hours. Employees just don't have to monitor or respond outside their ordinary hours. So I think that's an important point to flag as well. Yeah. So the reform really matters for roles that have been informally treated as always on, even though they were never meant to be on call. So that includes roles like administrative staff, rostering or scheduling coordinators, support staff managing last minute shift changes. I see that a lot in the healthcare space. So the new law helps to reset the expectation in these roles. I've got some practical examples which I thought might be helpful. So a reasonable refusal. For example, a payroll assistant ignores a 10 p.m. text about a non-urgent task that can wait, right? That's a reasonable refusal. An unreasonable refusal is a paid on-call manager that doesn't respond to an urgent safety incident. If someone's on call, they're a senior manager and they're being paid for it and they don't respond to an urgent safety incident, that could be classified as an unreasonable refusal. Reasonable contact, but optional to respond is another example. So an after-hours message that just shares information for the next day. Unreasonable contact, another example might be repeated non-urgent after-hours calls or texts. So there's just a few examples there that I think might help to set the scene. So when the right does not apply, so the right does not apply for small business until August this year. It only just came into effect for small businesses, or where the employee is under a lawful direction and refusing would be unreasonable, like I briefly touched on. There are a few best practice steps for employers to manage the right to disconnect. I've just put a few here on the slide. I'll expand on it a little bit. Best practice tips: review communication habits, especially late night or weekend messaging.
Yeah.
Update or introduce the right to disconnect or after hours contact policy, which steps out, the do's and the don'ts, the ifs, whens, the maybes. Clarify in position descriptions who actually needs to be available. Use tools like scheduled emails to avoid unnecessary after hours contact is a helpful one. Automate the process as much as you can.
That is a good
Uh,
one.
yes, yeah, that's right. Consult with employees when making changes. This consultation piece, I feel, is, I don't feel, I see more often than not is absolutely lacking, where you've got senior managers who are either implementing a policy and procedure or drafting position descriptions, but they're not consulting with employees who need to be involved in that consultation phase. And then also train managers on what urgent actually looks like. So urgent might look a little bit different to everybody in the workplace.
Yeah.
Some training there might be beneficial. So I'd say that summarises the right to disconnect rules. Unless there's anything you wanted to add there, Freddie, before I move to the next slide, anything that
No.
you're seeing in the workplace or questions that you're commonly being asked?
No, it was a good summary. And at the end of the day, that doesn't prevent the employer to send that email or to send that, but also
Mm.
that means that the employee doesn't have to respond immediately unless it's unreasonable not to do so. So I think it's a pretty good summary that you gave us.
Absolutely. It's the
Yeah.
right to
Yeah.
refuse. All right, so let's discuss
This is
non-compete
the
clauses. I
juicy
actually find
one.
that
Sorry, Jaylene. This is
this
the
is,
juice. Yes, this is the one that comes out every single
yes,
time, in particular what I do when
hmm
employees are moving from one company to the direct competitor, and a lot of employees
hmm
are actually putting non-compete clauses to avoid, to at least, try to not get talent moving from one business to the competitor. But those clauses are
yes.
just, yeah, I really am
Yeah, look,
curious
it
to
is it
hear
is a
your,
very interesting space, and there's a
yeah.
lot of big changes that are coming.
Hmm.
So I thought it'd be good to start to unpack what the government has announced. Where are we right now? So the federal government has confirmed that it intends to ban most non-compete clauses for employees earning below the high income threshold. So that is around 183,000 from July this year, and then it's indexed each year. So the plan is for these reforms to take effect from 2027 after consultation and the passage of the legislation. So it gives employers a transition period to adjust how they protect their business interests. Because at the end of the day, employers are concerned, they're wanting to protect their business interests, but we've got to balance restricting employees' rights to move and work within their geographical region.
Yeah.
So why is the change happening? I think it helps also unpack the why. So the government's view is that non-compete clauses, they limit job mobility, it suppresses wage growth, it slows down innovation, and it holds back career progression, especially for low to middle income workers who don't have much bargaining power.
Yeah.
So productivity reviews have also found that when employees move freely between employers, wage rise and businesses become more competitive, and non-competes can get in the way of that. Let's unpack what will be prohibited. So under the announced reforms for employees below that high income threshold, most standard post-employment non-compete restraints will be unlawful. It includes clauses that try to stop employees from joining a competitor for a defined period of time, starting a business in the same industry, working within particular geographic areas, or waiting out this cooling off period before taking a new role if that period operates like a non-compete. So in simple terms, if the clause prevents someone from working in their chosen field after they leave, it will likely be banned for employees below the threshold.
Yeah.
So even with a broad ban on non-competes for most workers, employers will still they will still have important tools to protect their businesses. So these are expected to remain lawful. So, for example, businesses can focus more on their confidentiality clauses, ensuring that employees must not misuse confidential information or share trade secrets or pricing or strategies with competitors. They can focus more on non-solicitation clauses, so clauses that stop employees from poaching clients, suppliers, or colleagues for a limited time. So they can still focus on setting up protections in these areas. Another area businesses should be focusing on is intellectual property clauses. So employers can still protect their inventions, their trademarks, their software, and other IP they created, employees created during their employment.
Sorry, Jaylene, out of curiosity, the non-solicit clause that can be non-soliciting clients, customers, colleagues and stuff, will that have a timestamp? As in, you can't call the same customers or account for 6 months, or like will
Yeah,
it
so
have,
it's a good question, and I think it's a matter of watch this space because we're still watching these reforms unfold. I'm interested to see how and where we land on that piece. But you can
yeah,
employers can still continue to draft their non-solicitation clauses now to protect their interests.
okay.
Uh, the government also suggested some limited non-compete restraints may still be allowed for employees earning above the high income threshold or executives with access to highly sensitive information, provided that the clauses are narrow and genuinely necessary. So, the details will be confirmed once the legislation is released. Uh, Again, I think it's important to unpack what it is and what it is not. So, what it is a major shift aimed at increasing workforce mobility, reducing reliance on these broad restraint clauses that now seem to apply to almost every contract I read. It used to only be for senior executive managers. And what it is not, it's not the removal of all avenues for employers to protect legitimate business interests. So, it would just be a change on how those protections operate. I've got a few examples here that I thought might be interesting. So, what is likely to remain lawful? Preventing a departing employee from taking client lists, pricing models, or internal documents, strategy documents. What is likely to be unlawful for those below the income threshold? So, a clause preventing an employee from joining a competitor within 3 months of leaving. That's a reasonable period of time. What's likely to remain allowed for high income senior roles is a carefully tailored non-compete for senior executives with access to commercially sensitive or strategic information. I just want to add a quick anecdote here. I had a client recently who was driving forklifts in a warehouse, and he had the most rigid non-compete clause I think I've ever seen. Didn't have access to any sensitive information, didn't have access to client lists, and still had a very rigid non-compete clause. And couldn't go to any other warehouse, or so he thought, within a very wide geographical region. So I think employers should start to see that that's an unreasonable restriction to put on someone in that role that doesn't have access to very sensitive information.
Yeah.
So a few steps here of what employers should do now. So even though the laws aren't in force yet, the direction is fairly clear. Organisations should be preparing now. It's important to audit all employment contracts and identify which roles currently contain these restraints. Strengthen your confidentiality, IP, and non-solicitation clauses. So these will become more important as we move forward. Review internal access controls. So not every employee needs access to sensitive information. Maybe have a look at who has access to what, and can you put some controls in place to reduce the spread of sensitive information? And then plan ahead rather than waiting for 2027. I mean, we're almost in 2026. All of a sudden, it'll be 2027. Here we are. Rules are in effect. The change, it does require a structural, not just a contractual shift. So it's a good idea to start preparing now. So there's an outline on the current legal landscape in this space. Is there anything else you wanted to add before I move to the next slide?
No, that was pretty good, and I think it clears the air on a lot of these non-compete clauses, in particular for roles that don't have that level of seniority. I talk to candidates a lot of times where they have these
Mm,
clauses and it's somehow that they feel that they can't join a competitor or they can't join another business for 6 months or they won't be able to work or they will have be hit with legal letters and all that. So I mean, it's good to make a distinction, obviously, depending on the role you
yeah,
have in the company.
absolutely.
If you're very senior and have access to IP or sensitive information, that makes sense. If you're,
Hmm.
an employee of a business,
Hmm.
they can't prevent you to make a living and to join another company in the field that you've chosen as your career field. So just,
Absolutely. And think about it in a very practical sense. If you're in a small regional town and there's only three hair salons and you quit your job and there's a non-compete, very strict rules around your mobility in your region,
yeah,
well, there might not be any other jobs available to you in that space.
you have to get another job that pays you less or like maybe not having
Mm.
not working for a while, which will be very unfair on any
Hmm.
employee really. So
Yep, absolutely. Another interesting space we're going to speak about is pay secrecy. Now, this is also an area the law has shifted strongly towards
mm,
transparency.
mm,
I think it's important to unpack the core legal position first,
yeah.
um, which which is some background on where this all started. So, essentially, since December 2022, employees have a workplace right to disclose their pay to colleagues or third parties, ask others about their pay, and choose not to, let me start again, choose not to disclose their pay. So this right, it cannot be overridden by contract. We
Hmm.
briefly spoke about this earlier, didn't we? So
Yeah,
any clause
it's been
trying
recent.
to impose pay secrecy is
Yeah.
void, and attempting to enforce it breaches the Fair Work Act. Did you want to mention something there, Freddie, that what you're seeing?
Yeah, I was about to say, I read a lot of contracts for the job that I
Mhm.
do. The contract gets sent to me and then I send it to candidates. And there's a lot of these clauses that say something along the lines of the employee cannot disclose their pay with any colleague, managers, or third parties. And
Mhm.
they've just written there. And I'm like, you can't have that clause. It's just, yeah. So I'm glad that you're clarifying this as well for
Yeah,
us.
that's right.
Yeah.
There's a few more things to unpack here too, which I think might help any employers that are listening today. So there is one narrow exception. So if the contract was signed before December 2022 and has not yet been varied in any way since, then the secretly clause may technically still exist on paper, right? But importantly, the employee still has the right to disclose their pay. The
Okay.
employer cannot legally enforce the pay secrecy clause, and the employer cannot take adverse action against an employee for discussing pay. It is a workplace right. So the moment anything in the contract is varied, so for example, a pay rise, promotion letter, hours have changed, there's new duties, etc., then the clause becomes automatically void. So in practice, that means that old secrecy clauses may still appear in contracts, but they have no enforceable effect. And it's interesting that you mentioned there that you're seeing it in new contracts post December
Yeah.
2022. So, yeah, there's a stronger argument there that these clauses they might be written on paper. It's well and good, but they're not. They're void and don't have enforceable effect.
Also, would it be the same if they ask to sign a non-disclosure agreement, an NDA? Is that same thing, or that will be for?
So the NDA is used in fairly limited circumstances, and it's probably another topic for another day.
Hmm.
But it cannot override the pay secrecy clause, which is a workplace right.
Okay,
A separate matter. Yeah.
okay.
But that's an interesting question. I think that we probably where the NDA can be used and can be enforced. We're seeing sits in terms of NDA being used in sexual harassment matters or bullying matters. So yeah, let's definitely table that one for conversation for another day. I think it's important to continue to unpack why the law has changed in terms of pay secrecy. So why has this pay secrecy rule come into effect? Um, Essentially, it's a shift away. The shift away from pay secrecy, it was driven by very clear evidence that pay transparency leads to fairer and more equitable workplaces. So when employees are prevented from discussing their pay gaps can remain hidden, especially for women, young workers, culturally diverse employees, and employees with limited bargaining power. So the reforms, the goal of the reforms, they aim to reduce the gender pay gap, increase accountability when setting salaries, prevent any outdated pay decisions from becoming entrenched in the organisation, and encourage consistent evidence-based remuneration practices. So that's the basis as to the why. So it's, essentially, in short, when information is shared, inequalities can be identified and fixed sooner. That's the why. Again, I think it's important to unpack what it is and what it is not. So what it is a protection that gives employees control over whether they discuss their pay. What it is not, it's not a requirement for employees to publicise their salary. It's not permission to pressure others into disclosure. I unfortunately have seen that in the workplace, the pressuring of having these discussions in the workplace. It's an employee's choice if they wish to disclose. And it doesn't prevent people choosing to keep their pay private. So that choice is protected just as strongly if they don't want to have it disclose their pay.
Okay.
I've also got a few examples here. I think examples are very important because they can bridge the gap between these theoretical concepts and what it actually might look like in practice. So an example of lawful behaviour, let's say there's two colleagues that discuss their pay to check if they're being paid consistently. Unlawful behaviour is a manager saying, we don't discuss pay here, or disciplining someone for doing so. Sensitive behaviour, an example, is an employee politely declines to share their salary, and that decision must be respected. There's a few examples there that I think might be helpful.
Yeah.
A few employer obligations which employers should turn their minds to now is removing pay secrecy terms from contracts and templates, ensuring managers do not enforce any old clauses that may still appear, train leaders on how to respond when pay discussions arise, and then also consider formalising remuneration frameworks to support fairness and transparency.
Yeah.
So I think there's a few steps there that employers can start to take now. I think also that in workplaces now have a much greater visibility of how people are paid. So it means that, inconsistencies, they do show up faster. And employers must be prepared to justify remuneration with objective criteria, not these informal and historical decisions. So that summarises this topic. Hopefully that's helpful for anyone watching today. And the last topic that we've got to discuss is actually quite a large topic. So I'm going to split this one over a couple of slides. And it's quite a hot topic, I find, recently with the recent Woolworths and Coles case that came before the federal court. So I want to unpack reasonable additional hours. We'll discuss the offset and absorption clauses versus overtime, and then I'll unpack the findings in these cases.
And this is another good one, Jaylene, because again, I read there's this clause that is super vague that says the employee can be required to work additional hours as required to do your job, pretty much, but you don't know what's reasonable, what's required. So it feels like, what's the parameter really that we're looking at?
Yeah, absolutely. And we'll definitely step through that. I've also seen contracts where the employer has just absorbed these, what they would consider reasonable additional hours into the contract and say, instead of a 38-hour week, you're expected to do a 40 or 42-hour week. We've just already factored in your reasonable additional hours. No, that is not what employers should be doing. So I'd like to step through the legal foundation. Again, I think it's important to understand the framework first and then step through the do's and the don'ts and provide some examples. So, reasonable additional hours. The National Employment Standards set ordinary hours, generally 38 hours per week for full-time employees, and agreed hours for part-time employees. Employers may ask employees to work these reasonable additional hours, but reasonable is determined by a statutory test in the Fair Work Act. It considers a number of factors. So I'm just going to step through what those factors are. So it has to consider any risk to health and safety, the employee's personal circumstances, for example, caring duties. I'll provide an example just after I finish this list on that one. It has to consider the needs of the workplace, whether the employee is entitled to overtime or penalty rates, whether the employee is compensated for additional hours. It needs to factor in the notice given to the employer, any notice of refusal by the employee, the usual patterns of work in the industry. Each industry has its own usual patterns of hours. The employee's role and responsibilities, whether any averaging arrangement applies, and any other relevant matter. So you can see that there's an extensive list there that needs to be considered on an individual basis. Now, coming back to the employee's personal circumstances as one piece in statutory test. Now, I had a client that requested flexible work arrangements. We'll also unpack that to collect her children at 3 o'clock every day. The employer just factored in these reasonable additional hours. Instead of finishing at 3, had to finish at 4 every day. Now, to absorb what the employer considered reasonable additional hours. Her contract actually completed at 3, but they added on the extra hour and mandated that she must complete at 4. Yeah, there's a few things to unpack in that one, but it cannot be something that's this set, forget, absorbed into the ordinary hours within the week. Now, a practical point here is that a contract saying reasonable additional hours, it does not make all extra hours reasonable. The test must be applied objectively on a case-by-case basis. So, again, a few examples, which I think is helpful. Reasonable might be staying 20 minutes late to complete a critical task. So you've stayed 20 minutes late on one day a week to complete a very critical task. Unreasonable is expecting a part-time employee with caring duties to stay back 2 hours with no notice or compensation, which is similar to the matter that I just mentioned earlier. So there's some examples of reasonable versus unreasonable. Now,
it's reasonable to state in a contract your working hours are 40 hours a week. End of.
Well, each situation needs to be analysed on a case-by-case basis. But if the purpose is to make the contract 40 hours a week when ordinary hours would be 38, no, that would be considered unreasonable. You cannot increase the hours in a contract to just create a blanket rule that there's these additional 2 hours a week to factor in the reasonable additional hours.
Okay. Cool.
So even if additional hours are reasonable under the National Employment Standards, awards and enterprise agreements may still trigger overtime, penalties, and allowances. So this is why we have to look at it at a case-by-case basis. So many awards, they will contain rules about maximum daily ordinary hours, the spread of hours over, is it 6 a.m. to 6 p.m.? It'll map out any penalty rates for evenings, weekends, public holidays, minimum break requirements as well, minimum engagement periods, and detailed overtime calculations. So we have to look at the relevant modern award or enterprise agreement. So a key point here is that complying with the National Employment Standards, it does not guarantee compliance with an award. So an example might be a retail manager may not be able to refuse a Sunday shift, but the award may still require the employer to pay significant Sunday penalty rates. So again, case-by-case situation, looking at your industry, what awards or enterprise agreements guide the process in determining the hours that are affiliated with each individual employee. So offset and absorption clauses, I think, is a really interesting area to unpack. Now, we refer to these offset clauses to allow employers to set off award entitlements like your overtime, your penalties, your allowances, and your loadings against a higher salary. So if an employer is going to pay an employee a higher salary, assuming that you're grouping together, setting off all these award entitlements into a higher salary amount. They are lawful, but only effective when the clause is very clear and specific about what entitlements are being offset and absorbed into this salary. The salary must be high enough in each pay period to cover all award entitlements that actually arose in that period, and the employer keeps accurate records of hours worked. That one's really important. Keeping accurate records of hours worked. And we'll come to an example in a moment. There are some common pitfalls that we see. So the common pitfall is assuming a salary automatically replaces award obligations. Very common pitfall. Or not recording hours, so removing the evidence needed to prove a lawful set-off clause. Or using a very broad generic offset clause that don't list specific entitlements. So again, I've got a few examples of effective versus, let's say, effective versus failure. So an effective example is you have a well-drafted clause, clear time records, and clear reconciliation showing that the salary exceeded award entitlements for every pay cycle. A failure might be this very generic clause, there's no time records, and the employees are working outside the award spread of hours, resulting in, significant underpayments. So I think it's really important to pause there for employers to consider if they are using these offset and absorption or set-off clauses in their contracts, and they're not, tracking the hours or ensuring that there's an annual review at least to ensure that if there are changes in the modern award, if there's a change in the person's role and classification within the modern award, that the salary is sufficient to cover all of the award entitlements. So some modern awards, they also include annualised wage provisions that operate separately from these contractual offset clauses, and they come with very strict compliance rules as well. So award-based annualised wage arrangements, they typically require written agreement, a detailed start, finish and break records, an employee acknowledgement of the hours that they worked, annual or more frequent reconciliations, and top-up payments for any shortfalls within the required timeframe. So, for example, let's say we have an employee who's under the clerk's private sector award, an annualised wage arrangement. It requires daily time records, employee sign-off, and annual reconciliation. If the salary didn't cover the award entitlements for the year, then the employer must pay the difference within I believe it's 14 days. So a key point here is that if an employer chooses to use an award-based annualised wage arrangement, then there's very strict compliance is essential. So failure to comply, it can invalidate the arrangement and expose the employer to an underpayment risk. Now, I have a slide here on the Woolworths and Coles case. Now, this is a recent case, and I also find this is particularly interesting. It just happened in September this year, where the federal court found both of these supermarket giants, they underpaid thousands of salaried managers. Yes, eek, that's right. That was my thoughts exactly.
Yeah.
Now, the court found that, and I bullet point them here, the court found that annualised salaries did not properly account for overtime, penalties, and allowances. The offset clauses could not operate because there were insufficient time records. Underpayments accumulated over many years, and remediation obligations were significant and ongoing. So the key point here, the key message is that if employers don't keep accurate time and attendance records, it becomes extremely difficult to prove that employees were paid correctly, especially where overtime, penalties and allowances may apply. Now, if this can happen to supermarket giants, it can happen to anybody.
Yeah.
I'm going to assume that they've got large teams, they've got internal leave, and it still happened. So Yeah, it's definitely an area to turn your mind to if you're using these offset absorption clauses. Now, common risk areas and best practice tips. I've sticked in a few here. Now, common risk areas, it's for salaried supervisors and managers who are still on award coverage, and employees working variable rosters. Now, sectors that are highly impacted is your retail, your hospitality, care, logistics, and admin. Now, there are some best practice tips here on the screen that I think it's worth stepping through each of them.
Yeah.
It's important to assess reasonableness each time. So don't assume that extra hours is always permitted. Identify and apply the correct award or enterprise agreement, ensuring that managers know the triggers. Draft offset clauses very carefully. Name the specific entitlements that are being absorbed into this annualized salary. Maintain accurate time records. That's essential for set off, annualized wages, and compliance. Reconcile regularly. So compare the award entitlements to salary paid at least annually. Train your managers. So they need to know when overtime and penalties apply. Train those that are managing the rosters to ensure that we're double checking any award provisions. Fix the issues ASAP. So early correction, it prevents escalation, and then it also signals good faith. It shows that the organisation has good intentions and they're being as proactive as possible to correct any issues that they've identified. Be aware of wage theft laws. Now, wage theft is also a very interesting space. So, from January this year, intentional underpayment is a criminal offence. I just might just say that again. So, intentional underpayment, if you've identified that there's an underpayment, intentional underpayment is a criminal offence. So, honest mistakes are not criminal, but still require full back payment, and it can still attract civil penalties. So, it's a very high risk space. It's very important to turn your minds to this area and ensure that you've set the framework up to ensure that you're monitoring this space at least annually, or when awards change. The bottom line at this point. Issues must be addressed early to avoid significant legal and significant financial consequences. Yeah, so that is everything that we wanted to unpack today. I put a little slide here at the end if anyone wants to reach out and contact me directly. I think we've unpacked a lot there to unpack the framework, the what, the why, what is, what isn't, and then also some best practice tips for employers that are wanting to be proactive. They're wanting to set up the framework right from the beginning, to sit in the prevention space, like I said, to hopefully not move into that litigation space that unfortunately we see happen more often than it probably ever needed to.
That's right. And bottom line, if you're uncertain or if you don't know, just go and ask a specialist like yourself, because you can get yourself into big troubles if you just ignore all these things. And organizations sometimes, if they don't have a big HR department, or they may not be across all these things, they can still use contracts that were drafted 10 years ago and they're just using the same thing. It carries a lot of risks.
Yeah,
Financial,
absolutely.
reputational, everything. Like you really need to make sure that you've got all your
Yeah, and I might just add to that working in private practice, I would say 80% of the matters that I saw coming through the door were all preventable. And it was eating at my soul to think that this could have been absolutely avoidable, if the employer probably first was aware of the legal framework and what measures they should implement to ensure that they are complying with the law. I've now shifted more into a HR advisory type role to help employers set up the framework from the beginning, to not see them, well, ideally to not see themselves head down the path where all of a sudden there's an unfair dismissal matter or a general protections claim, and there's financial consequences to head down that path. There's definitely financial benefits to set the framework up right from the beginning.
That's right. Get it right from the
Yeah, so
beginning, and then
yeah,
you can avoid.
yeah,
Yeah,
well, it's an educational seminars like this. It's like I said, it's just doing a small part to put information out there. It might trigger a thought for one manager in one workplace in one industry, and it can make all the difference. So
absolutely.
it's been really good to participate in this with you, and perhaps we'll
Thank
do a
you
few
so
more in
much
future.
for sharing all your knowledge with us today, Jaylene.
Yeah, it's been a
It's been
pleasure. I
great.
very much enjoy being in this educative space. I think it's really important to get information out there.